Good evening from the Supreme Court, the highest court in the land. And we're at the end of the first day of a 4-day hearing on Brexit. Who should trigger Article 50 of the Lisbon Treaty to take the United Kingdom out of the European Union? Can it be the government acting alone with its prerogative or executive powers, or should it be Parliament? Well, Gina Miller, a businesswoman, brought the case to the High Court last month, saying it should be Parliament that triggers Article 50. The High Court judges agreed. The government has appealed against that decision here at the Supreme Court. So now, for the first time, we've got 11 Supreme Court judges who are hearing this case. And the President of the Supreme Court, Lord Neuberger, began today with an opening statement in which he said that the judges will decide this purely on matters of law, not politics.
I would like to take this opportunity to remind everyone who's taken an interest in these proceedings that the Supreme Court exists to decide points of law which fall within its jurisdiction. The justices of the court are of course aware of the public interest in this case, and we are aware of the strong feelings associated with the many other wider political questions surrounding the United Kingdom's departure from the European Union. However, as will be apparent from the arguments before us, those wider political questions are not the subject of this appeal. This appeal is concerned with legal issues, and as judges, our duty is to consider those issues impartially and to decide the case according to the law. That is what we will do.
Well, that was Lord Neuberger there, President of the Supreme Court. Whatever the court decides, and we won't get their ruling here until the new year, it will have immense political and constitutional implications. Political implications for the government, for Theresa May, because it will affect her timetable for Brexit. She has said she wants to trigger Article 50 by the end of March. If the government lose here at the Supreme Court, they'll have to put a bill before Parliament on Article 50, and that could be amended or delayed, and that could interrupt the government's timetable on Brexit. So for the government, we heard today from the Attorney General, Jeremy Wright, QC MP, putting the government's case to the Supreme Court.
My three submissions are these. First, that the Foreign Affairs prerogative is not an ancient relic, but a contemporary necessity. Including the powers to make and withdraw from treaties, it is a fundamental pillar of our Constitution as a sovereign state, and it is essential to the effective conduct of public business. Second, that the prerogative operates as part of a dualist system, including in the EU context. And third, that the prerogative operates wholly in accordance with parliamentary sovereignty. Parliament has a clear understanding of the constitutional function and usefulness of these powers, and where it chooses to limit them, it does so carefully and specifically. The position of the respondents and others in this case has always been that they have no interest in derailing Brexit, but only in defending Parliament's role in the process. But if this is all about standing up for Parliament, I say Parliament can stand up for itself. When it comes to leaving the European Union, Parliament has had full capacity and multiple opportunities to restrict the executive's ordinary ability to begin the Article 50 process, and it has not chosen to do so. However much they may wish it had, those who support parliamentary sovereignty, should we submit, respect this exercise of parliamentary sovereignty too.
Well, that was the Attorney General, Jeremy Wright. We also heard from James Eadie QC, and for much of the day he was putting the government's case as well. And he came under some cross-examination really from the bench, from the Supreme Court judges, who at times challenged his interpretation of the Constitution. Let's have a listen to one or two of the exchanges.
Mr. Eady, do say that the European Communities Act 1972 was neutral as to whether the United Kingdom was a member of the European communities?
We say that it proceeded on the fundamental assumption that ultimate decision on the international plane was a matter for government. And I'm going to come to develop that submission.
But Mr. Eady, you've shown very convincingly that our entry into the EU was a joint effort. The exercise of prerogative power by the executive and the exercise of legislative power by Parliament.
Yes.
And so, put very simply, one of the arguments that you will have to deal with is if our accession was the result of joint effort, should our departure not equally be so?
Well, my Lord, the submission I make is that the joint effort, as it were, in the 72 Act is a joint effort in the sense that it assumes that all the prerogative powers continue to exist and be operated. And so all that this is doing, this Act, is not to, well, put it in the positive, this Act is designed, and that's all that Part 1 does, to deal with transposition. It doesn't authorise, it doesn't purport to be a joint effort in relation to the going in. It simply assumes and is premised on the continued existence of that power. And withdrawal, therefore, is entirely consistent, to put it in my Lord's helpful way, it's entirely consistent with that framework, because when you withdraw on that basis. You withdraw in exercising the prerogative powers that sit in parallel to and are the premise for the 1972 Act.
Well, you've told us that it was all carefully considered, so presumably you've got evidence for that.
Well, my Lord, my Lady, we'll check overnight to make sure you have the white or the green papers, whatever there was.
So that was James Eady QC for the government. Let's get the views of three experts who've been listening in to the proceedings today. Gavin Phillipson, Professor of Public Law at Durham University, Alison Young, Professor of Public Law at Oxford University, and the BBC's own legal affairs correspondent Clive Coleman. Clive, you first of all. It's been a day where the government have put their side of the case. What did you make of it?
What I think is really interesting is that really this legal case for me is dancing on the head of a legal pin, because what the government are saying, they've sort of refocused their argument from the High Court, and what they're saying is that actually the 1972 Act, which brought these rights into domestic law, is actually a sort of vehicle, a conduit, and that these rights are being brought in a way so they're not sort of nailed down statutory rights like they would be if they were in an Act of the British Parliament that had no European element at all. And the fact that because they have that status and they're brought in by an international treaty, and the international treaty is brought in by the use of the royal prerogative, those rights can be removed or taken away. Now, I think for normal people, for ordinary people, that is a very difficult concept to get your brain around. But on the head of that legal pin, a huge amount turns. And James Eady got some pretty difficult questions from the judges about that very subtle argument. But that, for me, is the heart of it.
And Alison Young from Oxford University, do you think James Eady for the government was convincing in the case that he put to the court today?
I think he made a much stronger case than they did in the High Court, I think, by focusing much more clearly on this argument that they're not really statutory rights because of this conduit, this pipeline, as Clive was explaining. So I think it is a stronger case, but still, it's because it's so technical and so detailed, it's quite hard to be persuasive. And also I think he's not thinking about the deeper constitutional consequences of the European Communities Act. And I think we'll expect questions on that, I think, tomorrow, trying to pin down what these deeper constitutional principles are and how important they are for this technical argument.
Gavin Phillipson, the Attorney General was saying, if this is a question of who triggers Brexit, the government or Parliament, he said, well, look, if Parliament really wanted to have the final say on this, they could have written that into the Referendum Act that paved the way for the referendum, and they didn't do that. Were you persuaded by that argument?
I can see the argument can be made. I mean, personally, I think that's just because legislation, in fact, is drafted by the government. The government clearly never thought it was going to lose the referendum and made no preparations for losing the referendum. So I think it was actually just oversight.
Well, that will strike many people as quite extraordinary that you can just omit to say a key thing in a piece of legislation of that importance?
It does seem extraordinary, doesn't it? I mean, I've heard there's been a protester shouting, this is costing hundreds of millions of pounds, all these lawyers and judges and paper going in and out the court, and it could have been probably all solved with one line in an Act of Parliament that had said, if there is a leave vote, the government shall have power, notwithstanding the European Communities Act, to trigger Article 50.
But do you think this is a constitutional clash, if you want, between the government and its prerogative powers, these powers that were inherited from the kings and queens of old, and Parliament? Is that how you see it?
Yes, it's one of those cases that comes up where the government's prerogative powers come into collision with statute, and there are cases like that that have been cited already to the court. Many of them go back to the early 20th century. But it's never happened before in a case as huge as this, where the government's claiming under its prerogative, we can take the UK out of the European Union without any say-so from Parliament at all, and all of your EU law rights will just evaporate. That's the government's claim.
Clive Coleman, is that the essence of this? It's not only a case of huge political significance for Theresa May and the government, but of constitutional significance, of how the constitution in this country works.
I think it's the most important case about where power lies in our constitution in decades. You know, where the limits of executive power end and where parliamentary power, begins. But one of the other things I think is absolutely fascinating, it's a constitutional tension in another way, which is this is a judicial review. This has been triggered by two ordinary citizens. And I think first time around at the High Court, when we covered this case, I think a lot of people really just didn't get how powerful judges are in our constitution, because they have the power to stop ministers in their tracks through the mechanism of judicial review if what ministers are proposing to do is unlawful. And for me, that is one of the great constitutional tensions of our time, between a very powerful executive, the irresistible force, if you like, of a very powerful executive that meets the immovable object of a group of independent judges who, through the mechanism of judicial review, have power to stop ministers, as I say, if what they're proposing is constitutionally unlawful.
And Alison Young from Oxford University, for the judges here at the Supreme Court, well, having seen their colleagues at the High Court vilified by some of the media as, quote, enemies of the people, what will be going through their minds? Will they think how difficult this case is not to be seen acting politically?
I think they will obviously be aware of the political ramifications, particularly having seen what's happened before. But I think it's very important, as Clive was explaining, to recognise that this is essentially a legal question, which is why we have so many legal technicalities, so many discussions of old case law. And what they'll be focusing on is the strength of the legal arguments from both sides. So yes, there will be political ramifications, but in their heads, it's about the law.
You mentioned case law. I don't want to get into the obscurities, but some of it was quite obscure, wasn't it? About a hotel owner in the First World War. Just in a nutshell, tell us why on earth that is relevant to Brexit.
Okay, that is relevant because it's an old case that looked at this battle between prerogative powers and legislation. And so the idea was, if you have a prerogative power that says you can requisition a hotel, and you have legislation that says you can requisition a hotel but you must pay compensation, you must use the legislation in that case, not a prerogative power. So that's why they're referring to it, because it's another example of this clash between legislation and prerogative powers.
All right, very well explained. Thank you very much indeed. Alison Young, Gavin Phillipson and Clive Coleman, thank you very much indeed. Well, that's it at the end of the first day of this 4-day hearing. Tomorrow we'll be hearing more from James Eadie QC for the government, and also from the other side of the argument we'll be hearing from Lord Pannick QC, arguing that it is Parliament that must trigger Article 50 to begin the process of Brexit. That's it from me here at the Supreme Court. Good evening.